that if you find that either or both of the defendants, Mr. Richards or Mr. Armstrong, were negligent and that their negligence was a factor or was a cause of the accident here, you must then next consider whether the plaintiff, Deborah Wright, was negligent and whether her demeanor contributed to the cause of the accident. As I told you with respect to the issue of the negligence of the defendant or fault and whether it was a cause of the accident, the plaintiff has the burden of proving that. I now charge you that the burden is on the defendant, Richard and Smith, to prove that Ms. Roebling or any other defendant was negligent and that negligence contributed to causing this accident. That would be in question number 5 or 6. Members of the jury, if you find that Ms. Roebling was negligent and that her negligence did contribute to causing this accident, you will then move to question number 7 and deal with the issues of apportionment of fault between the plaintiff and the defendants here. Let me tell you also that if you find 2 of the 3 parties here that they were negligent and that their negligence was a cause of the accident, you will then move to question number 7. That will be more completely stated to you in the instructions after each of the questions. But if any 2 of the 3 of the parties here are found to have been negligent and that their negligence caused the accident, you must then go to question number 7 and apportion fault. If you find that only one of the parties was negligent and not the others, then you need not move on to that. Certainly, if you find that both of the defendants were not negligent here, you need not move on and deal with the question of Ms. Roebling's negligence. In any event, if you have found 2 of the 3 parties to have been at fault in some way, then weighing all the facts and circumstances, you must consider the total negligence, that is, the negligence of all of the parties which contributed to causing the accident here, and determine what portion of fault is chargeable to each of those parties. In your verdict, you will state the percentages that you find in question number 7. Obviously, the total of those percentages must equal 100%. For example, if you would find that each of the parties here was equally negligent, you would report that each was 33 1/3 responsible. Should you find that one party is more negligent than the other in causing this accident, you would assign a higher percentage to that party and a lower percentage to the other parties, of course with the total of those percentages equaling 100%. Ladies and gentlemen, I have told you I would get to the issue of burden of proof, and I will now do that. As I've told you, in this case, the plaintiff claims that the defendants were negligent and that that negligence caused the accident. The defendants each claimed that he did not cause the accident, but that the negligence was as a result of someone else. And the defendants say that even if they were negligent, that other parties were also negligent in causing this accident. As I've told you, the plaintiff has the burden of proving that the defendants were negligent here and that defendants' negligence was a substantial factor or a cause of the accident. The defendants each have the burden of proving that the plaintiff or the other defendant was negligent and that the plaintiff or the other defendant was a substantial factor or a cause of the accident. We now move on to the further